Welcome back to The Deep Dive. It is Wednesday, February 4th, 2026. And today we're doing something that might feel a little heavy, but I promise you, it is arguably one of the most important conversations we've had on this show.
I would agree with that. It's a heavy lift, but a necessary one.
We're tackling a subject that, frankly, usually comes with a massive amount of noise. You say the name Jeffrey Epstein, and immediately the room temperature changes. People get angry, they get conspiratorial, they get defensive. It's a topic that has generated millions of clicks, thousands of hours of cable news screaming, and probably, terabytes of internet forum arguments.
And most of that noise generates heat, but very little light.
Exactly. And that is why we are here. We are going to strip all of that away. We are not doing a true crime episode today. If you're here for the lurid details or the gossip, you are probably in the wrong place.
Right. We're not here to relitigate the tabloids.
We are looking at a very specific, very dense, and I think very illuminating piece of source material titled Power Without Accountability: The Epstein Institutional Failure.
And that title really tells you everything you need to know about where we're going today. This isn't a biography of a criminal. It's a structural analysis. It's an autopsy of the systems that allowed him to operate.
Right. The mission today is to move beyond the headlines, beyond the names, to understand the system under strain. We're talking about the machinery of justice, the levers of power, and what happens when those things, when they grind against each other.
Or when they fail to engage at all.
Good point. If you're listening to this, you're the learner. You want the shortcut to being well-informed, but you want the real information, not the hysteria. So let's unpack this.
I think the best place to start is with a metaphor used right at the beginning of our source material. The text describes the Epstein case not as a window to look through, like a window into some criminal underworld, but as a mirror.
A mirror. That's interesting, because usually people treat this case as a freak show. Like, look at this monster over there, completely separate from our normal, polite society.
Precisely. And that is a defense mechanism. If we treat it as an anomaly, a freak show, as you said, then we don't have to learn from it.
We can just put it in a box.
We can just say, well, that was a one-off nightmare. But if we treat it as a mirror, it reflects how our society handles three very specific things: power, accountability, and consequences.
So the thesis is that what happened in this case reflects the vulnerabilities in our own institutions.
Yes. The same institutions we rely on for traffic tickets, for contract disputes, for our own safety.
Yeah.
The vulnerabilities are baked in.
That is a scary thought, that this isn't an exception, but a reflection of a design flaw.
It should be scary. It implies that under the right, or I guess the wrong circumstances, the system is designed to fail in this specific way.
Okay, before we dive into the analysis, I want to set some ground rules, and these come directly from the source material itself. We are prioritizing verified information. We are practicing restraint. The goal is clarity. We aren't asking what really happened in a conspiratorial sense. Like, we aren't going to debate security camera footage from the jail.
Right. We're asking, what does this teach us? It's the different question.
A much more useful one. We need to separate evidence from speculation, and that is so much harder than it sounds, especially with a topic this charged.
It really is.
So let's start with part one of our deep dive: evidence versus speculation. The source makes a really strong point right out of the gate about what it calls the legal baseline.
It does. And this is where we have to be very disciplined. Legally speaking, looking at the court records, looking at the actual verdicts handed down by a jury, the reality is stark.
What is it?
Only 2 individuals were convicted in connection with these specific crimes: Jeffrey Epstein and Ghislaine Maxwell.
That's it. 2 people.
2 people.
I can hear the listeners screaming at their devices right now. But what about the lists, the flight logs? There are planes full of people.
And that reaction is totally valid. It feels intuitively wrong that an operation of this scale, lasting this long, boils down to 2 convictions. But the source material forces us to look at the difference between involvement in a social circle and criminal conviction beyond a reasonable doubt.
And those are 2 very, very different things.
Worlds apart, legally.
So this brings us to the documents. I feel like every few months, even now in 2026, there's a new list or a new document dump that gets everyone on social media whipped into a frenzy.
It's become a sort of cottage industry.
But the source material has a very specific warning about this. It says, and I'm quoting here, "Presence in records is not proof of guilt."
This is such a crucial distinction. We have to understand what these documents actually are. We are talking about flight logs from a private jet. We are talking about personal contact books, like an old-school Rolodex. We are talking about diary entries.
So these documents place people in proximity to Epstein. They prove association.
Yes. Proximity, association. They do not, on their own, prove criminal behavior.
Let's use an analogy here because I think people really get hung up on the flight logs.
Okay, let's do it.
Imagine a really wealthy, charismatic guy. He throws massive dinner parties,
Oh, wow.
and he owns a private jet, and, he offers rides to people who are going to the same conference in Davos or whatever.
Sure, a common occurrence in that world.
So you accept the ride, you go to the dinner, you sit next to him, you talk about, I don't know, physics or philanthropy.
Yeah.
You are trying to get a donation for your university.
Right. A completely plausible, non-criminal interaction.
Unbeknownst to you, in the back room of the house, or later that night after you've gone home, this guy is doing something horrific, illegal, evil.
Yes.
Does your name on the flight log or the dinner party guest list make you an accomplice to the crime that happened in the back room?
Legally, no. Absolutely not.
They're not even close.
No. Morally? Ethically. Maybe you have questions to answer later about why you were friends with him or why you didn't see the signs. But criminal guilt requires intent and participation in the crime itself.
Mm-hmm.
The flight logs prove that person A was on a plane with person B.
They don't prove what happened on the plane or what happened after they landed.
Not to a legal standard of beyond a reasonable doubt. They can be corroborating evidence in a larger case, but they are not the smoking gun in and of themselves.
So the public sees the name and thinks guilty.
Exactly. And this connects to lesson 4 in our source material, which is about the danger of information without context. When these massive sets of documents were released, especially the unsealed court filings from the Virginia Sheffield lawsuit, it created this paradox.
A paradox? How so?
For researchers, for lawyers, for journalists doing the deep work, it created a degree of clarity. It filled in the gaps of the timeline. But for the general public, it created massive confusion.
Because the public isn't trained to read a discovery document. We see a name and we fill in the blanks with the worst possible assumptions.
Of course. You aren't. You see a headline that says, famous actor named in Epstein files. You don't click the link to read the 300-page document to see that the file was actually a deposition where a witness said, I think I saw that actor at a cocktail party once, fully clothed, talking to 5 other people.
The nuance is completely lost.
Instantly. The name becomes the verdict in the court of public opinion.
The source explicitly states, data alone is not truth. That is such a powerful line. We live in this age where we think having access to the raw data makes us experts.
Mm-hmm.
But raw data without legal context is just noise. It can actually be weaponized.
Facts become weapons. That's the quote from the text. And think about how dangerous that is. You can take a factual entry, a date, a name on a log, and wrap a completely fabricated narrative around it. And because the core data point is true, the lie travels halfway around the world before the truth gets its pants on.
It puts the responsibility of interpretation on us, and most of us aren't equipped for it. The source talks about how these lists circulated without any verification. Assumptions replaced evidence.
It's difficult, though. I get it. Because we want the list to be a key. We want to believe that if we just decode the flight logs, we'll solve the mystery. It's an attractive, simple solution to a complex, ugly problem.
But the source is telling us the mystery isn't in the list. The mystery is in the system that let the list exist in the first place for so long.
That's the real story.
Which is the perfect segue. If the legal baseline is that only 2 people were convicted, and the documents are just beta points, not verdicts, why does this case still feel so unresolved? Why does it feel like the system fundamentally failed?
That is the million-dollar question. And that leads us to the core of the analysis in the source. It's not about the lack of evidence. It's about the presence of influence.
So let's go there. Part 2. Lesson 1. How power warps systems. This is the why. If there were credible allegations for years, and we know for a fact there were, why was accountability delayed for so long?
The source is very direct here. It says, power changes how systems respond. It's a mechanism. It's not magic. It's not necessarily a secret cabal in a smoky room deciding to break the law, which is what people imagine.
Right. It's more subtle than that.
It's about how institutions react to pressure, to incentives, to risk. The text lists 3 specific shields that high-profile, wealthy defendants benefit from.
Okay, let's break those down, because I think we need to understand the mechanics of this. The 3 shields of power. What's number 1?
Number 1 is elite legal representation.
Okay, so let me play devil's advocate. Everyone has a constitutional right to a lawyer. Why is having a good lawyer a shield in a negative sense? That just sounds like the system working.
It's a matter of scale. We are not just talking about having a good lawyer who makes a nice closing argument. We are talking about a legal army. People like Alan Dershowitz, Ken Starr. These are not just lawyers. They are institutions unto themselves.
So what does that army do?
When you have unlimited resources, your legal team can flood the zone, as they say. They can file motion after motion after motion. They can challenge every single procedural step. They can contest the font size on a subpoena just to slow things down.
It's a resource war, a war of attrition.
Exactly. They can make the pursuit of justice so expensive and so time-consuming that the system just gets tired. They can bury a prosecutor's office in paperwork until the state says, you know what, we just can't afford to fight this anymore. We have 100 other cases to prosecute.
That is deeply depressing. It's literally buying time and buying delays.
And time is the enemy of justice. Memories fade. Witnesses move away or lose their nerve. Public interest dies down. It's a key strategy.
Okay, shield number 2.
Political relationships.
Now, this is where people usually jump to, like outright bribery or something, but the source is more nuanced, right?
Yes. Bribery is a specific crime. It happens, but it's risky and it's crude. Political relationships is often about soft power.
What does that mean in practice?
It's about access. It's about the benefit of the doubt. It's about being the guy who donates generously to the Police Benevolent Association, or the guy who hosts the fundraiser for the district attorney's reelection campaign.
It makes it harder to aggressively investigate the guy you just shook hands with at the mayor's charity gala last month.
Exactly right.
Yeah.
It humanizes the defendant in the eyes of the power structure. He's not a criminal suspect. He's Jeff, who we saw at the club last week, or the man who funded the new wing of the hospital.
That familiarity creates a psychological buffer.
It absolutely does. It makes the system pause before striking. It encourages second guessing.
And that pause, that brings us to the third shield. And honestly, this is the one that I found most fascinating and most disturbing in the source text. Institutional hesitation.
This is the most insidious one because it's not illegal. It's
Right.
just human nature within a bureaucracy.
Walk me through this. I'm a district attorney. I have evidence against a powerful person sitting on my desk. Why am I hesitating?
Okay, imagine it's a Tuesday morning. You have a stack of 50 cases on your desk. 49 of them are against regular people, drug dealers, burglars, whatever. They have public defenders. You know you can process those cases in 6 months. You know the likely outcomes. They are routine.
Okay, standard procedure.
Then there is the 50th case. It involves a billionaire with connections to world leaders. You know that if you file charges, his legal army is going to investigate you. They're going to dig into your past. They're going to leak stories to the press about you. They're going to drag this single case out for 5 years. They're going to drain your department's entire budget for the fiscal year. They're going to make your life a living hell.
So it becomes a personal and professional risk calculation.
It becomes career risk. If you swing at the king and miss, your career is over. You look incompetent. Maybe you even get sued. So the institutional hesitation kicks in. You start asking your staff, are we sure we have this thing nailed down? Is it airtight? Maybe we need another month of
That
investigation.
isn't another month.
And then another.
Yep.
And suddenly a year has gone by. It's risk aversion disguised as diligence.
Perfectly put. Prosecutors are human. They want wins. They want to clear their caseload. They don't want a quagmire that could end their career. Power creates a quagmire.
The source says, justice does not always operate equally when power enters the room. It's chilling because it challenges that fundamental promise we all learned in civics class, right? Equal justice under law.
This case study shows that the mechanics of justice, the gears and the levers, get gummed up by influence.
It wasn't a lack of evidence that caused the 2008 deal. That is the key point from the source. The allegations were there. The victims were there. It was the influence that acted as a buffer, a shield, a delay tactic.
And I think the source wants us to apply this broadly. This isn't just about this one case. Think about corporate fraud. Think about environmental regulations.
Right. It's a lesson about the nature of power itself. Whenever you have a massive imbalance of resources between the accused and the accuser, the system warps. It bends.
And that warping effect is often invisible until it's far too late. Which segues perfectly into the next lesson from the source material, the role of secrecy in all of this.
Part 3. Lesson 2, the erosion of trust through secrecy.
The source talked a lot about sealed agreements and confidential deals, and specifically that infamous non-prosecution agreement from 2008 that we mentioned in the timeline.
This is critical. One of the primary reasons this case festered for so long was that so much of it was handled behind closed doors.
Let's talk about the NPA, the non-prosecution agreement. For the listener who isn't a lawyer, what is that tool usually used for?
Typically, it's a tool used for corporations. Let's say a huge bank violates a regulation, like money laundering. The government says, okay, we won't criminally charge the bank because that might collapse the financial system and cost millions of jobs. But you have to pay $1 billion fine, you have to fire the CEO, and you have to let us put an independent monitor inside your company for 5 years.
So it's a tool to fix a systemic problem without destroying an entire institution.
Exactly. Using an NPA for a sex crimes case involving a single individual, that is highly, highly irregular. And the specific language of this agreement granting immunity not just to Epstein but to any and all potential co-conspirators was breathtakingly broad.
It sounds like a get-out-of-jail-free card for an entire network.
It essentially was. And because it was negotiated in secret and, crucially, without the victim's input or knowledge, which was later found to be a violation of the Crime Victims' Rights Act, it created this massive trust gap.
The source has a great line on this. Transparency delayed becomes credibility lost.
That's the maxim right there. When you hide the mechanics of justice, you create a vacuum. The public knows something fishy is happening, but they can't see the details. And when they can't see it, they imagine the absolute worst.
And that's where the conspiracy theories come from.
Exactly. Speculation fills the void of facts. If the institutions had been transparent from the beginning, if the prosecutor had held a press conference and said, here is the deal we made, here is why we felt it was the best we could get, people might have been angry. They might have protested.
But they would have known what happened.
They would have known. There wouldn't have been this deep, corrosive suspicion that the entire government is part of some satanic cabal protecting him. The secrecy itself was the original fin that fueled a decade of madness.
Secrecy is a petri dish for conspiracy. The source asks 3 questions that the public was asking for years. Why so long? Why now? Why only partially?
Those are the questions that arise when you drip feed information over a decade. It makes it feel like a cover-up.
And even if there are valid legal reasons for some secrecy, like protecting the privacy of victims or, innocent third parties, the institutional reflex to just hide everything backfired spectacularly.
It made the institutions look complicit, even when they were perhaps just being bureaucratic or, as we said, risk-averse.
It's a huge lesson for any institution in the modern age. If you want trust, you have to show your work. You cannot ask the public to just trust us anymore. That era is gone.
That's long gone.
So we have power warping the system and we have secrecy eroding trust. But while all this abstract institutional failure is happening, lawyers filing motions, prosecutors hesitating, there are real people paying the price.
And this is the most important part of this deep dive. Part 4. Lesson 3, the vulnerable pay the price.
This section of the source material it's heavy. It focuses on the victims, and specifically on the timeline of their suffering and their fight to be heard.
It is the most painful lesson, and we have to really sit with this. The length of time victims had to wait to be believed. We are talking about decades for some of them.
Decades. Think about that. You are a teenager, something traumatic and illegal happens to you. You summon the courage to tell the police.
Right.
And nothing happens. And then you see the person who hurt you on television shaking hands with presidents, being celebrated as a philanthropist.
The psychological gaslighting of that must be unbearable. It destroys your sense of reality. It tells you that your story doesn't matter, that you don't matter, that the system isn't for you.
The source makes an observation that I hadn't really crystallized before. It says that validation for these women didn't come first from the courts. It came from journalists.
That is a profound indictment of our justice system. Think about that. We have the FBI. We have local police departments. We have prosecutors' offices. We spend billions of tax dollars on these institutions specifically to investigate crimes and validate victims. But in this case, they stalled. They failed. They cut a secret deal.
It took Julie K. Brown at the Miami Herald. It took dogged, thankless investigative reporting to go find these women, listen to them, and verify their stories when the state wouldn't.
It took the Fourth Estate to do the job of the state. And while we should absolutely celebrate that journalism, we should mourn the fact that it was necessary in the first place.
The justice system shouldn't require a viral news story to wake up and do its job.
No, it shouldn't. The text mentions that many victims spoke up early on. They weren't hiding. They went to the authorities in the mid-2000s. They were ignored. Or they were pressured into silence.
Systems often move slowest when the victims are young, powerless, or inconvenient. That is the quote from the source. And I think inconvenient is the operative word there.
It's a brutal word to use for a human being.
Horrible.
But it's accurate to the system's point of view.
Yeah.
These victims were inconvenient. They were often from lower socioeconomic backgrounds. Maybe they had troubled family histories. They weren't the perfect victims that juries and prosecutors love.
And accusing a billionaire is extremely inconvenient for that prosecutor we talked about earlier.
Right. So the path of least resistance for the system was to ignore them, to dismiss them.
It reminds me of the concept of the perfect victim. If you aren't a nun or a choir girl with a spotless past, the system immediately looks for reasons to doubt you.
Exactly. And predators know this. Predators like Epstein specifically target vulnerable populations because they know the system won't rush to their defense. They weaponize the system's own biases against the victims. It's part of the crime.
So the implication here is that a justice system that cannot hear the vulnerable is incomplete. It's not actually doing its job.
It's failing. It's that juries and prosecutors love.
And accusing a billionaire is extremely inconvenient for that prosecutor we talked about earlier.
Right. So the path of least resistance for the system was to ignore them, to dismiss them.
It reminds me of the concept of the perfect victim. If you aren't a nun or a choir girl with a spotless past, the system immediately looks for reasons to doubt you.
Exactly. And predators know this. Predators like Epstein specifically target vulnerable populations because they know the system won't rush to their defense. They weaponize the system's own biases against the victims. It's part of the crime.
So the implication here is that a justice system that cannot hear the vulnerable is incomplete. It's not actually doing its job.
It's failing its primary mandate. The system is supposed to protect those who cannot protect themselves. In this case, for a very long time, it protected the one person who needed no protection at all.
So we have this failure of speed, we have this failure of validation, and then at the very end, we have the ultimate failure of closure.
Part 5. Lesson 5, Justice Beyond the Verdict.
This brings us to the end of the legal case. In August 2019, Jeffrey Epstein died in custody. And the source points out that legally, the case closed upon his death. You can't try a dead man. The federal charges in New York were dismissed. Technically, he died an innocent man in the eyes of the court on those charges, right?
Technically, yes. The presumption of innocence holds until a jury says otherwise. And since the trial never finished, the guilt was never legally established for those specific federal charges.
That feels incredibly unsatisfying. Just wrong.
It is. But the source argues, and this is vital, that socially, the case never closed.
Because justice isn't just a conviction, right? It's not just a piece of paper that says guilty at the end.
No. Justice is a process. It is a public ritual. It involves testimony. It involves cross-examination. It involves the accused having to sit in a room day after day and face the accusers. It involves a full public reckoning.
The ritual of the trial.
Exactly. A trial is a ritual of truth-telling. It puts facts on the permanent historical record under oath. It forces society to look at the ugly details. It allows the victims to speak their truth directly to the perpetrator's face.
And we were robbed of that. The victims were robbed of that.
Completely. And that unfinished nature, that lack of a final chapter, is what allows the distrust and the conspiracy theories to linger and fester.
It connects back to our restraint theme. Because the opportunity for total legal clarity is gone. We will never have a jury verdict on those specific charges. We have to live with a certain amount of ambiguity.
And human beings hate ambiguity. We want a clear ending. We want the movie to end with the bad guy in handcuffs and the credits rolling.
You didn't get that ending. We got a messy, abrupt cut to black in a jail cell.
We did. And because of that, the source argues we have to be very careful. We have to accept that there are things we will never know for certain. And we shouldn't try to fill those gaps with fantasy or speculation just to make ourselves feel better or to fit a preferred narrative.
That's hard. Restraint is hard when you're angry and you feel like you've been cheated out of an ending.
It is. But it's necessary if we want to actually understand what happened and learn the right lessons from it.
So if we can't get legal justice because the primary defendant is dead, what about? What about reputational justice? What about the other people who are in his orbit?
Well, that leads us to part 6, implications for public figures and leadership.
This goes back to the documents we discussed earlier. Lesson 4 in the source material talks about the public figures named in these files. The question the host in me and the learner in me wants to ask is, if they weren't convicted, does it matter? If they didn't break the law, if they just went to a dinner party, why do we care? Why are we still talking about Prince Andrew or Bill Gates or any of the other famous people who are in that orbit?
The expert in me says, It matters because of the crucial distinction between legal guilt and ethical responsibility.
Okay, let's unpack that. Legal guilt versus ethical responsibility.
The source says reputation is not protected by legality alone. Just because you didn't commit a crime doesn't mean your behavior was acceptable or wise. In the public eye, especially for a leader, association invites scrutiny, and silence invites speculation.
So if you are a leader, a CEO, a former president, a public figure, and you are hanging out in this orbit,
You have a higher responsibility. You
Vegas.
can't just say, well, the FBI didn't arrest me, so everything's fine, nothing to see here.
that's a pretty low bar for leadership. I wasn't arrested.
Exactly. It's the lowest possible bar. The text says proximity to wrongdoing, even unknowingly, demands transparency, not defensiveness.
That is such a good leadership lesson, and one that so few people seem to have learned, because the instinct is to deny, right? To get defensive, to say, I didn't do anything illegal, leave me alone, no comment.
But that doesn't work. Not in the modern world. Public trust is shaped by what is ethical, appropriate, and responsible, not just what is strictly legal.
So let's play this out. Imagine you are a CEO of a major company. It comes out that 10 years ago, you had 3 meetings with Epstein. Maybe you were trying to do a grant for your university. Maybe you were looking for an investment. You didn't know he was a trafficker. Or, more likely, you chose to ignore the rumors. What is the right move today?
The right move is radical transparency. You have to provide the context before the leak forces you to.
So you don't wait for the reporter to call you with a gotcha question.
No, you get out ahead of it. You issue a statement. You say, yes, I met with him. Here is why. Here are the dates. Here's what we discussed. In hindsight, it was a mistake. I missed the warning signs, and I deeply regret that association.
That sounds so simple, but nobody seems to do it.
Because their lawyers and PR teams tell them not to. They are afraid. They think admitting any connection is fatal. But what this case shows us is that the cover-up of the connection, or the minimization of it, the dishonest explanations, is often what actually destroys the reputation.
The public can forgive bad judgment if it's owned. They rarely forgive deception.
It's the difference between I made a mistake in judgment and you can't prove I was there.
One is a leadership statement. The other is a legal defense.
And in the court of public opinion, the legal defense usually loses. When you hide behind no comment or legal threats, you look guilty, even if you aren't legally guilty of a crime.
Context is often the first casualty in the court of public opinion.
It is, and that's the danger. But it's also the reality that modern leaders have to navigate. You cannot rely on the legal baseline to save your reputation if you have failed the ethical baseline.
This has been heavy, but incredibly illuminating. We've covered a lot of ground here.
Oh, I have.
We've looked at the critical difference between evidence and speculation. We've seen how power acts as a shield through elite lawyers, political connections, and that institutional hesitation.
We've seen how secrecy destroys trust and how the system failed the victims by being too slow and treating them as inconvenient.
And we've recognized that justice is about more than just a gavel coming down at the end of a trial. It's about the whole story being told. So, as we wrap up, let's go back to that mirror metaphor from the beginning.
The Epstein case reflects how our institutions protect themselves, often at the expense of the vulnerable. It shows how easily truth is distorted when power and secrecy are involved. But ultimately, the source argues the real lesson isn't about one man. It's not about Jeffrey Epstein.
It's about us.
It's about the society that created him, enabled him, and looked the other way for far too long.
The source has a haunting phrase about how systems fail. It says they fail quietly, repeatedly, and for too long.
That really stuck with me. Quietly. We tend to think of corruption or failure as loud, explosions, scandals, sirens. But this failure was quiet. It was paperwork not being filed. It was sealed court orders. It was polite handshakes at fundraisers.
It was people just not doing their jobs because it was hard or risky.
And those thousands of quiet failures accumulated over years into a massive, screaming tragedy. A tragedy that destroyed lives and shattered public faith in the system.
And that's a wound that doesn't heal easily.
Exactly. The cost of silence is never neutral. Every time a system chooses silence over transparency, it is making a choice that has real damaging consequences.
And accountability delayed always leaves scars.
It does. And we are living with those scars now. The intense distrust in media, the deep cynicism toward government and the justice system, that is the scar tissue from cases like this.
So, here is the final provocative thought for you, the listener. This is the challenge the source leaves us with, and I want you to really sit with it. We've spent this time looking at how this happened in the past, but the mirror reflects the present.
If we accept that the cost of silence is never neutral, where else in our society are we currently accepting silence in exchange for comfort?
Where else are we letting systems fail quietly just because it's inconvenient to ask the hard questions? Is it in our tech sector, our financial institutions, our local governments?
That is the question to take with you. Don't just be angry about 2008. Be vigilant about 2026.
Thank you for listening to The Deep Dive. This was not an easy one, but understanding isn't about outrage. It's about learning how to do better. If you appreciate this kind of analysis, facts over noise, systems over gossip, make sure you're subscribed.
We'll see you next time.